First case of the morning, People versus Jacob Lee Laporte here, case number 236481.
For the record, John McLoud,
Thank you, Your Honor. Richard Schuster on behalf of Mr. Laporte.
All right, good morning. We're here for a status conference in this case today. Mr. Trush, we have this, I believe it's set for a final status conference. We have trials set to begin in a little under a month. So today would be the plea cutoff. How does your client want to proceed?
We intend to proceed to our trial.
Okay. Mr. Rolla, are there any issues that you foresee, or are the people going to be ready to go forward on the 14th?
I believe going to be ready, Judge. I would advise for the record that there was a amended plea offer of counts 19, 22, 26, 71, and 80 as a habitual second. With, of course, the condemnation of the weapons and then the restitution 2006-03-43. The amendment in that eliminated the felon in possession charge, which automatically would add on 2 years to a prison sentence. I'm sorry, the felony firearm charge, which had previously been reported to be pled to, which would add on an automatic 2 years. I just indicate that for the record.
And do you believe that we're still going to need 3 days of trial?
Consider the number of witnesses, Judge. I hope we can get it in 3 days.
Okay. Mr. Trush, any issues that you can foresee that we're going to need to resolve prior to trial?
No, I would second the prosecutor's sentiment. I think that 3 days is certainly going to be necessary. I'd be more concerned we'd need more time than less.
Okay. All right, so we'll continue with the trial is scheduled to begin on February 14th. That's a Wednesday. I think I probably will, and I'll note this for the status conference order today. I'll probably try to set up a conference call with counsel maybe a week prior to the trial date. Just given the number of charges here, we may need to make some adjustments to jury instructions and verdict form. I mean, it's going to be, this is obviously a little bit unusual in terms of the number of charges. So I think we'd be better off discussing that, before the trial, as opposed to trying to hammer that out during the time of trial. Do you have any objection to that, Mr. Roll?
No, not at all, Judge. I think that would be appropriate. Thank you.
Mr. Trush?
I would agree, Your Honor.
Okay. Either do you have any objection to addressing those kind of things off the record in the context of a conference call?
Not on behalf of people, no, thank you.
I'm sorry.
Sorry about that. Do you have any objection to addressing those issues? And we can make a record of things if we need to after, but addressing that at least primarily as a conference call type thing off the record.
No, I think that's appropriate.
All right, so the court will set that up, and then we'll go forward as scheduled. Mr. Rolla, anything else that we need to address today on this file?
I don't believe so, Judge.
Mr. Trush?
No, nothing further.
Mr. Laporte, do you have any questions at all?
You're right.
Okay, thank you. That's all for today.
I don't know.
And I was here by myself before we had anybody.
Oh, okay.
So, really,
Yeah, is it the speakers? Nothing's been changed. There should be nothing on
yeah.
the. Okay. Is it still?
Okay. Give me a good report.
Do you want me to email IT or just?
I guess let's just see how it goes. People versus Jeffrey Hurd, case number 236607.
The record, John, we're going back to people.
Thank you, Your Honor. Richard Schuster on behalf of Mr. Hurd.
And Mr. Hurd is present here in the courtroom today. This is set for a status conference. It looks like the last hearing we had was back in October. Mr. Hughes, where things are at from your side.
Yes, Your Honor, we would be asking this matter be set for a trial.
Right, Mr. Rolla, how much time does people need to be ready for trial?
Yeah. When my keyboard decides to start. There's not a rush, and I would advise the court we have 8 witnesses, although a number of them are police officers. There was a plea offer on the record of count 1, dismiss counts 2, and the habitual looks like second. Third. It was Amanda's case. Amanda's case, the habitual offender enhancement. We do have lab personnel, so that will be the case.
Any
It's
objections
gonna take
to
at least
setting
a
it
day and a
up?
half.
Day and a half.
At least, yes, Judge. Okay.
Mr. Trush, if it was at least 90 days out, is that enough time for you to be ready to proceed to trial?
Oh, absolutely.
Okay, and if we said for 2 days, do you believe that would be enough time?
I think that would be likely sufficient.
Mr. Rolla, are the people anticipating any pretrial motions or motions? In the May?
Don't see any at this time, Judge.
Mr. Trush.
I don't anticipate any, although I would ask the court to leave open a small window for us to explore that.
Okay. All right, so we'll set this for a 2-day jury trial, at least 90 days out. The court will set it in a status conference prior to that trial date. So Mr. Hurd, that final status conference will be your last appearance in court before trial. So to the extent that there's any further negotiations or plea discussions, that would be the last time to enter into a plea, okay? And then Mr. Trush, that would also be the motion cutoff, so you'll have at least 90 days, at least 60 days, probably a little more than that, to file and get any motions heard.
Understood. There's a valid issue I would like to address to the court.
Okay, what is that?
Mr. Hurd is on a tether as part of his bond conditions right now that was put in place by the district court. I would indicate for the court, there's been no violations of his bond to this point. And quite frankly, actually, the victim has attempted to contact him and he has blocked and ignored her. With that in mind, it doesn't pose a financial burden on Mr. Hurd. He has not violated in any way, shape, or form. I would ask the court to consider removing the tether at this time.
Judge, quite to the contrary, we hear the exact opposite, of course, coming from the victim, that she is not the one trying to contact him on knowing that there's many violations. But in light of the particular offense that's charged, we do not want the defendant to have any opportunity to be in contact with the victim. And we'd ask that the motion be denied.
Well, I mean, I see the name of the victim here. Is this somebody that's related in some way, or I'm just trying to understand the specific need or potential for contact?
Well, Judge, how do I want to put this? This is one where it's alleged that the sexual assault took place not only on the victim, but with the minor members of the victim's family, her kids, although they didn't witness it, they verbally, I guess, if you will, witnessed it. And the parties apparently previously had a relationship, but that was terminated long prior to this incident occurring.
All right, Mr. Trush, anything further that you wanted to state?
I would just indicate, I mean, per the police report, the allegation is that it happened in a household. I do believe that her still minor, but adult children were in the household when it is alleged to have occurred. They were not present when it occurred, but they were at the house. I would suggest, again, I don't see anything that sparks a specific need or concern for a tether here. again, obviously, when the district court imposed it, we complied, but I don't see a specific need for it.
All right, in looking at the charges here, it does involve 2 counts of criminal sexual conduct, 3rd degree involving force or coercion. Mr. Hurd is being charged as a 4th habitual offender, which means each of these charges carries with it a life, maximum possible penalty of life in prison. So given the severity of the charges in this case, and the nature of the charges involving criminal sexual conduct, I find that a tether is a reasonable restriction, reasonable condition of bond. And so the court is going to leave that in place, primarily for purposes of public safety and the safety of the alleged victim. So the court will deny that on request. Anything further, Mr. Truce, that we need to address today?
Not at this time.
Mr. Rolla?
No, Your Honor, thank you.
Okay, the court will send out dates for that final status conference as well as the trial dates. Mr. Hurd, it's just important that you stay in touch with Mr. Truce so that you're ready to proceed, okay? Thank you. Versus Ethan Gantz, case number 236546.
For the record, John McLoud,
Thank you, Your Honor. Church appearing on behalf of Mr. Gill.
Thank you, Mr. Gantz is present here in the courtroom today. This is set for trial to begin on February 29th. So this is a final status conference and the plea cutoff date. Mr. Truce, how does your client want to proceed?
Your Honor, thank you. We are at this time prepared to enter into a plea agreement. The prosecutor has offered that if Mr. Gantz pled to an added count 2 of criminal sexual conduct 4th degree, that count 1 would be dismissed. It would be our intentions to enter into that agreement.
And Mr. Truce, are you prepared to question your client as to the factual basis?
I would be.
Okay, good. Mr. Rolla, is that a correct statement of the plea offer?
It is, Judge, to the be to an added count 2 criminal sexual conduct 4th degree incapacitated person contrary to MCL 750520E1B.
And is that a 2-year?
That is, Judge.
Okay.
2-year person and class G felony and or $500. The Congress serves me correctly.
Thank you. Mr. Gantz, have you had a chance to talk to Mr. Truce about this plea agreement?
Yes.
And is that how you want to proceed today?
Yes.
You raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. Lower your hand. Mr. Gantz, you understand that under this plea agreement, you would be pleading guilty to a charge of criminal sexual conduct 4th degree, and that's a crime that carries with it a maximum possible penalty of up to 2 years. You understand that?
Yes.
That, are you currently on any kind of probation or parole?
I'm on probation.
Okay. Is your probation agent aware that you're entering this plea today? You understand that by pleading guilty in this case, that could result in a violation of your probation, and that you could face some additional penalties for violating your probation that are over and above whatever you may receive in this case?
Yes.
Okay. With all of those things in mind, what is your plea to this charge today?
Not guilty.
Okay, so right now you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you want it. You understand all those rights.
Yes.
And you understand that you're giving up and waiving all of those rights by pleading guilty, including the right to have a trial.
Yes.
Also, you don't have an automatic right to appeal the plea that you're making here today or to try to get it reversed. You you wanted to try to do that, you have to ask the next higher court up, the Court of Appeals, to hear your case. If they said no, then that would be the end of any appeal. You understand that?
Yes.
Has anyone threatened you with anything to get you to plead guilty?
No.
Has anyone promised you anything other than what we've said here in court today?
No.
Is it your own free choice to enter this plea?
Yes.
And are you pleading guilty because you are guilty? Mr. Trush, if you could establish a factual basis, please.
Thank you. Mr. Gens, were you here in Otsego County on or about February 14th of last year, 2023?
Yes.
And was that at 825 Center Avenue? Is that where you were living? I'm sorry, Village Parkway at the time?
Yes.
And on or about that date, was Anna Romero at your home?
Yes.
And Anna Romero is at your fiance's mother?
Yes.
And on that date, was she sleeping on your couch?
Yes.
And did you touch her buttocks?
Yes.
I don't think there's any additional questions needed.
Judge,
I think we need to establish it was done for a sexual purpose and not by accident or some other way.
And that was her bare buttocks?
Yes.
And that was for a sexual purpose?
Yes.
Thank you with that, Mr. Rolla.
with that addition, people are satisfied for sufficient factual basis to accept and skills of plea to add count 2. Courts comply with court rule statute as to accept those promises or other inducements not placed on the record. Thank you.
Thank you, Mr. Trush, as to those issues.
Your Honor, I believe the court has complied with court rule. There is a factual basis, and I'm aware of no threats, promises, or inducements.
Thank you.
I would ask the court if we could set the sentencing out 60 days. I've been in contact with a counselor to have a sexual risk assessment performed. Mr. Gens is very young. He actually does have potential eligibility for HIDA. Ultimately, I'd like both the prosecutor and the court to be able to review the risk assessment prior to sentencing.
Any objection, Mr. Rolla?
You get the assessment that people are not in any way in agreement with the HIDA situation from the sexual assault cases.
Okay. The court will set sentencing about 60 days out. Anything further, Mr. Trush?
No, thank you.
Mr. Rolla?
No, Your Honor, thank you.
Okay, Mr. Gens, just make sure that you stay in touch with Mr. Trush ahead of that sentencing date, okay? Thank you. That's all for me. Oh, I'm sorry, Mr. Trush, I need to make a record here. Thank you. The court finds the plea is knowing, voluntary, and accurate. The court is satisfied that there's a factual basis to support a finding that Mr. Gens is guilty of the added count 2, and the court will accept the plea to that count. The court will also adjourn the trial date that's currently set for February 29th in light of the plea today. Thank you. Somewhere. No, okay. People versus Thomas, Jesse Thomas, case number 236608.
Thank you, Richard Trush, on behalf of Mr. Thomas.
The record should reflect Mr. Thomas is present here in court today. Mr. Trush. Things are at with this case.
Thank you, Your Honor. When we were last here, we'd asked the court for a little bit of time. Mr. Thomas was working on putting together restitution money. We're almost there. We're better than halfway to having that money ready to pay the restitution. I'd ask the court to consider giving us another 60 days. I think we'll likely have it done in that time period.
All right, Mr. Rolla.
As long as the defense waives any speedy trial, purpose, people would have an objection.
On that, Mr. Trush.
Your Honor, we'd be prepared to waive those at this time.
Okay. Mr. Thomas, do you think within the next 60 days, you're going to be able to gather those funds together?
Well, I had 2 jobs, but I have no contact with Pamela. She came to Taco Bell 3 days in a row and they fired me for the server. So.
Okay. I think, you know, if we don't have things set at that next hearing, then I think that the court's gonna need to set it for a trial at that point. The bind over was in September, so we're 4 months on. So I think we need to look at that as a real cutoff date.
Understood.
Okay. All right, Mr. Trush, anything further on this file today?
No, thank you.
Thank you, that's all. All right, sir, can you tell me your name, please?
Barnett.
Barnett. All right, we're on the record in People versus Barnett. This is case number 236659. The record should reflect Mr. Barnett is present by video from Department of Corrections. If I could have counsel put your appearances on.
For the record, John, microphone down.
Thank you, Your Honor. Richard Trush on behalf of Mr. Barnett.
Okay. Mr. Barnett, just let me know if you have trouble hearing what's going on here in the courtroom at any point, please let me know, okay?
I can hear you.
Okay, good, thank you. This is set for a status conference today. It looks like Mr. Barnett was just found over in December. Mr. Trush, can you tell me where we're at with this file?
I can, Your Honor. This had a pretty quick turnaround. In fact, I think I just got the notice last week for this. Unfortunately, I had spoke to Mr. Barnett a few days prior to getting the notice, just through MDOC. There's another case that's working its way through. I think it's in Charlevoix. I've been in contact with his attorney, Mr. Gilbert there. We're trying to put together a resolution of both files at the same time. We have an offer here that has been extended to us. I think it's one that we're likely to take advantage of. Frankly, it's the other county that we're kind of waiting on. But as the court's aware, because of the credit situation with People versus Givens, we don't want to jeopardize that. So I asked for 30 additional days. At that time, I think we'd be prepared to resolve the case.
All right, Mr. Rolla, any objection to that?
No, Judge, I would just indicate for the record my office received 180-day notice from the Department of Corrections on November 16, 2023. We'd asked for the defendant to officially indicate on the record they're waiving that issue.
Mr. Trush, can you make those inquiries for your client, please?
I don't know that I'd be in a position to really waive his speedy trial rights, given that he's in MDOC. He's effectively sitting on dead time, and he's not going to get parole while he has this holding hanging out over. In fact, I think you can indicate, Mr. Barnett, your parole's already been denied on the basis of this, correct?
Yes, sir.
I don't think I'm in a position where I would be able to waive his speedy trial rights. I don't want to put him in a position where we have no timeline.
All right, Mr. Rolla, I guess we'll have to deal with that issue if it arises then.
That's fine, Judge. And again, this is the 180-day rule as opposed to speedy trial, because as the court's well aware, there were two very distinct things.
Right.
And I would indicate adjournments that are requested by us should toll that.
Right.
So
Very good, Judge. I think that's sufficient people's position. Thank you.
Okay. All right, and you said 30 days?
yes.
Okay, so Mr. Barnett, the court's going to set this for another hearing in about 30 days, and Mr. Trush will be in touch with you along likely with your counsel in the other case as well. Do you have any questions at all?
No, that's it.
Okay, thank you. That's all for today, and the court's going to disconnect at this time.
Yeah, thank you. Good day.
Next hearing is 9:30. McLoud. He's latched in Crawford, is that correct, Mr. Trush?
That is correct.
I know we have a Redford and Crawford, but I don't see them joining on Zoom yet, so let's just take a quick break and then we'll come back out in about 5 minutes. Okay, are you Raymond McLeod?
Yes, Your Honor.
Okay, thank you. We're on the record now in People versus McLeod. This is case number 236613. The record should reflect Mr. McLeod is present today by video from Crawford County Jail. If I can have counsel put your appearances on.
Record, John, Mike, Malone,
Thank you, Your Honor. Richard Trush on behalf of Mr. McLeod.
Mr. Trush, how do we want to proceed in this case today?
Thank you, Your Honor. In this matter, we actually have two, I don't call them companion cases, but two other cases out there. One in Crawford County, which the court probably remembers. I think we were up not long ago on that, and we asked for a little extra time for a global resolution. To just come to my attention last week, there's also a matter, I think, in the nominee, which I was contacted by his attorney there. We're trying to roll or fold that into our global resolution as well. So I would suggest to the court another 30 days would probably be appropriate to coordinate all those.
Okay. Mr. Rolla, any objection to that?
No, Judge. Thank you.
Mr. McLeod, were you able to hear that?
Yes, Your Honor.
Do you have any objection to proceeding that way?
No.
Okay, so we'll set it for a status conference plea hearing in about 30 days. Mr. Rolla, anything further we need to address on this file on behalf of the people?
No, Your Honor, thank you.
Mr. Trush?
No, nothing further.
Mr. McLeod, did you have any questions at all?
No, Your Honor.
Okay, thank you. That's all for this hearing today, and the court's going to disconnect at this time. Right, and our next matter is Mr. Jurek's case. Have you had any contact with Mr. Jurek yet this morning?
Not this morning. I did speak to him last week.
Yeah, that's 10 o'clock, so we'll take a short recess.
And yeah, correction, he did actually message me about 5 minutes ago and said he's running about 10 minutes late because of the road conditions.
Okay. All right, we'll take a short recess and back on the record in just a few minutes. Flagstaff, if you want to come forward, I think we have your. Mr. Brown, are you able to hear me okay?
Yes, Your Honor, thank you.
Okay, we're on the record in People versus Corby, Mexico, case number 236537. We have Mr. Brown present today by video on behalf of Mr. Mexico. This hearing was set for 10 o'clock. It's now 10:15. Mr. Mexico is not present here in the courtroom or by Zoom. Mr. Brown, have you had any contacts with him?
I have, Your Honor, and actually it appears he's calling me right now. If I could have just a brief second.
All right. I will put you on hold for just a minute.
Thank you.
Okay, Mr. Martin, if you can unmute yourself, please.
Okay. Morning.
Are you Jared Martin?
I am.
Okay, we're on the record in People versus Jared Martin. This is case number 236620. And let the record reflect Mr. Martin is appearing today by Zoom by prior approval of the court. If I could have counsel put your appearances on, please.
Judge Mike Flagstaff, number 79314 on behalf of Mr. Martin.
Join the microphone back to the people.
Thank you. Mr. Flagstaff, we're set for a status conference in this case. Can you tell me where things are at from your standpoint?
Yes, Your Honor. As the court is aware, my client is still in inpatient rehabilitation. He has been given kind of a schedule or roadmap at this point. My understanding is that he will be completed with the inpatient portion of this treatment February 18th, at which point he'll move to intensive outpatient, Judge. I have been in contact with Sheboygan County Treatment Court. I'm optimistic. However, Judge, what they're telling me is we just need him. We can't proceed without him at this point. So that's kind of where we're at, Your Honor. I know it's been a while, but provided we're not testing the court's patience, I would like him to complete inpatient rehabilitation and move forward with the success he's gaining.
All right. I mean, what are you anticipating for a resolution of this case?
I'm anticipating that he'll be accepted into treatment court. Now I'm aware that that's not a given, obviously, and this court's aware that's not a given. But from my conversations with treatment court, I think he is going to be at least considered. I think he's a good candidate.
All right. Mr. Rolla?
Well, Judge, obviously, to be accepted in the treatment court, he's going to have to be entering a guilty plea to drinking and driving, in this case, a third offense. I don't think that was mentioned on the record.
I would agree with that.
Yeah. Okay. Mr. Rolla, what's your position on Mr. Flagstaff's request here for
Please, Judge.
Man,
My keyboard is like frozen at the rest of the world.
I apologize. This tip's not timely, Your Honor, but Mr. Roll was kind of to sign it this morning.
If I recall correctly, Judge, we had a situation where he was back in Harbor Hall and inpatient treatment back on November 20th, 2023. We had the matter adjourned again on December 18th, 2023. I suppose if the people hear a specific fixed date, that I can give the court a better response on to what our position would be as to how long it's going to take before we get this matter resolved. I know the court has timelines.
Yeah, so I guess here's where I'm at with it, Mr. Flagstaff. I'm willing to set this for a plea hearing, plea cutoff date of the court's March motion day, so beginning of March. That would be approximately 2 weeks after Mr. Martin's indicating he's going to be released from treatment. I understand that's a quick turnaround, but this case was bound over in September, and I think we need to have a resolution by March. Otherwise, the court's going to set this for a trial, but that would be a plea cutoff is that March date. So if we're going to have a plea, it needs to happen at that time.
Understood, Your Honor.
So, Mr. Rolla, do you have any objection to that as a timeline here? And I think that gives us a hard cutoff for things to either happen or not happen.
And again, that was what the people were effectively requesting. With that addition, Your Honor, we don't have any objection.
Okay, so Mr. Martin, were you able to hear all of that?
Yes, Your Honor.
Okay, so that means that the court's setting a deadline for you, regardless of whether it's treatment court or what the resolution is. If there's going to be a plea to any lesser charges in this case, it's going to happen on that March date. Okay, so whatever you need to do between now and then to get things worked out with Mr. Clackstad, we're going to need you to do that.
Okay, yes, Your Honor.
All right, Mr. Clackstad, anything else we can address today for the record?
No, Your Honor, thank you.
Mr. Rolla?
No, Your Honor, thank you.
Mr. Martin, did you have any questions at all?
I think I'm all aboard with what's going on. I'm good with everything.
Okay.
Thank you very much.
Very good, thank you. The court's going to disconnect at this time. Thank you.
Thank you, Judge.
Okay, Mr. Brown, were you able to make contact with Mr. Mexico?
I was, Your Honor. He should be coming in the courtroom any second now. He was coming from Kalkaska. He was actually down in the jail trying to figure out where to go.
Okay, Mr. Mexico, if you come up to the podium here, please. Thank you. And again, this is People versus Corby, Mexico, case number 236537. Mr. Mexico's present here in court today. If I could have both counsel put your appearances on.
For the record, Your Honor, my call behalf of people.
Larry Brown on behalf of Mr. Mexico.
All right, Mr. Brown, this is set for a final status conference today. We have a trial date currently set for February 26th. So this would be the plea cutoff. How does the defense want to proceed today?
Your Honor, if I could have Mr. Roller review the plea offer.
Yes, Judge, I indicated it was an offer that was extended on May 10th, 2023. Offers to counts 1 and 2 for dismissal of counts 3, 4, and enhancements. There's $70 restitution, joint and several the same.
All right, thank you.
And I would also indicate that the people will be filing, if this goes to trial, a 404B notice, which will indicate our intention to use defendant's prior March 10th, 2017 larceny in a building for the 13th Circuit Court conviction as part of that notice, and the defendant's intent to, how do I want to put this, be less than honest with the matters, in case he's trying to find some excuse.
All right, Mr. Brown.
Your Honor, I have discussed that offer. That is the offer that I currently have with Mr. Mexico. I will give him the final word, but it is my understanding that at this time we are going to proceed to trial.
Okay, thank you, Mr. Mexico. Is that how you want to go forward?
Yes, sir.
Okay, just want to make sure you understand that as the final status conference today is the last day that the court will accept any pleas to any lesser charges. So after today, we will proceed to trial. Is that how you want to go forward?
Yes, sir.
Okay. All right, so the court will proceed with trial. Again, it's scheduled for February 26th and 27th. So Mr. Mexico, you'll need to be here at 8:30 in the morning of Monday, February 26th. And then just make sure that you stay in touch with Mr. Brown between now and then so that you can properly prepare for your case, okay?
Sure.
And Mr. Rolla, to the extent there are any notices that need to be filed, if you can just file those within the time permitted under statute. Mr. Brown,
Shortly, Judge.
yeah, Mr. Brown, if you're gonna have any objections to any of the notices filed by the prosecutor, you'll need to get those, your objections filed and set for hearing prior to the trial date, okay?
Yes, Your Honor.
Okay. Mr. Rolla, anything further we need to address today?
No, Your Honor, thank you.
Mr. Brown?
Your Honor, I was planning on putting in a lesser included charge. I don't know how the court deals with that.
If you just want to submit that under the pretrial order, the prosecutor will submit his full jury instructions. You just need to file whatever additional or other instructions that you would request. You don't have to file a full copy.
Okay, thank you.
Okay. Mr. Mexico, did you have any questions? Okay, thank you. That's all.
Thank you.
And Mr. Brown, you're free to disconnect at this time.
Thank you, Your Honor.
All right, sir, are you free Picket?
Yes, sir.
Mr. Trush, I don't know if you've been made aware, we do have this arraignment that got added today.
I am.
Okay. We're on the record in People versus Corey Picket. This is case number 22640. The record should reflect Mr. Pickett's appearing today by video from the Otsego County Jail. This is set for an arraignment today on some alleged probation violations, 2 alleged violations. And Mr. Picket, have you been made aware of what the alleged probation violations are?
Yes.
And do you understand those violations, or do you need me to read those to you?
You can read them to me.
Okay, it's alleged that you committed a technical probation violation in that on or about November 15th of 2023. You failed to comply with your probation by being in possession of a weapon. It's alleged that you had a non-technical probation violation in that on or about November 15th of 2023. You violated condition 1 of your probation by violating a criminal law by possessing a firearm as a felon. Do you understand those allegations?
Yes.
A few things that I need to go through with you with regard to your rights. First of all, you do have the right to have a hearing as to whether or not you violated your probation as has been alleged. You also have the right to have an attorney present at any subsequent proceedings. If you can't afford an attorney, one would be appointed for you at public expense. Mr. Trush is a public defender. He's present here today on your behalf for purposes of this arraignment hearing. And then finally, if you are found guilty of the non-technical probation violation, it could subject you to the maximum possible penalty on your underlying charge, which is up to 10 years. Do you understand all those things that I've stated?
Yes.
Did you want to see if you qualify for a court-appointed attorney?
Yes.
Okay, so Mr. Trush, the court will refer this to Mr. Gilo's office for screening.
Your Honor, if I may.
Sure.
Mr. Pickett, I was appointed to you on a different matter on Friday. Has your financial situation changed in any way since then?
No.
He's gonna qualify.
Okay, so the court will direct that counsel be appointed. Mr. Pickett, the court's intention would be to enter a not guilty plea on your behalf today with regard to both of those charges. Is that how you want to proceed?
Yes.
Okay. And the court will enter a not guilty plea. The court will set this for a hearing. In terms of bond pending that hearing, Mr. Brunico, any position on part of the
Yeah, thank you. I did have contact with Mr. Pickett when the warrant was submitted. I advised him to turn himself into jail and surrender. It appears he did not and had to be picked up on the warrant. And given the violation, requesting a moderate cash should be filed.
Mr. Trush.
On the other charge, I already have a $50,000 bond that I'm not gonna be paying, and no way I'm gonna be able to even come close to even 10% of that. So I'm probably gonna be there for a year or more.
I was going to indicate he has a bond in the matter that he was arraigned on, I believe, on Friday. I'm also being told by Mr. Gilo he may have an arraignment in front of Judge Cooper this afternoon as well. In any event, I think a moderate cash bond is appropriate so that he can potentially earn credit.
All right. given that the underlying alleged violation involves possession of a firearm, the court has concerns for public safety, the court will set bond in the amount of $10,000 cash or surety, along with all conditions of probation. And then, Mr. Trush, do you want a chance to talk to Mr. Picket about the probation violation hearing in this case? I mean, if he doesn't post bond, obviously you're required to schedule that for 14 days unless it's waived, which the court will do, but I don't know if you're in a position to do that at this point to waive.
Yeah, I have not had a chance to talk to him. I would like to speak to him about that.
Okay, so the court will set this for hearing within 14 days.
Could I possibly have all my bonds? Could I possibly just have my other 2 bonds revoked? Have all my bonds revoked and I'm just gonna stay here for a year, so I'm not gonna be able to bond out.
So let me, are you saying that you have 2 bonds, something that you posted in other cases?
Yes, I have a possession of methamphetamine that I'm out on bond for, and a probation violation that I'm out on personal reconnaissance bonds.
Who represents you?
My time.
Who represents you in those cases?
You do.
Are those the ones from Friday that you got, that I was appointed on?
Yes.
So we'll make a motion to cancel your bond in those cases. We'll take care of that.
Okay. All right. Thank you, Mr. Pickett. That's all for today. The court's going to disconnect from the this time. People versus Cameron Federica, case number 236662.
Thank you, Your Honor. Richard Trush on behalf of Mr. Durka.
Mr. Trush, can you tell me where things are at this file today?
Yes, Your Honor. We are in receipt of an offer from the prosecutor whereby Mr. Bedurka admitted to counts 1 and 3, that being the possession of an analog and an improper license plate. Count 2 would be dismissed. In addition to that, there's not an objection to treatment under 7411 if he's qualified, which we believe he is.
Mr. Rowland.
Mr. Fenton signed a plea offer apparently in this particular matter on October 9th, which indicates an offer of plea to count 2 with proof of insurance and valid registration, and counts 1 and 3, I'm sorry. Yes, for dismissal of count 2. And there is an indication of no objection to 7411 if there's been a possible. Thank you.
Mr. Federica, have you had a chance to talk about this plea agreement with Mr. Church?
Yes.
Is that how you want to proceed today? Raise your right hand, please. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth, so help you God. Thank you. Lower your hand. Mr. Federica, are you currently on any kind of probation or parole?
Yes, sir.
All right. And you understand that by pleading guilty to count 1, which is possession of Suboxone, that the maximum penalty you could face would be up to 2 years and or a $2,000 fine.
Yes, sir.
And count 3, which is unlawful use of a license plate, that's a misdemeanor that carries with it a maximum penalty of up to 90 days and or a $100 fine. With those maximum penalties in mind, what is your plea to each of those charges today? Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial to question those witnesses. You have the right to have the court order any witnesses on your behalf to appear at trial. You have the right to remain silent during a trial and not have that silence used against you, and the right to testify at a trial yourself if you want it. You understand that you have all of those rights.
Yes, sir.
And you understand that you're giving up, waiving all of those rights by pleading guilty.
Yes, sir.
Has anyone threatened you with anything to get you to plead guilty?
Yes, sir.
Has anyone promised you anything other than what we said here in court today?
Yes, sir.
Is it your own free choice to plead guilty?
Yes, sir.
Are you pleading guilty because you are guilty?
Yes, sir.
So this happened on September 8th of 2023. Is that the correct date? On that date, were you operating a vehicle here in Otsego County? And did you have an improper plate on that vehicle?
Yes, sir.
And at that time, were you also in possession of some Suboxone?
Yes, sir.
Did you know that that's what that substance was? Did you have any legal right to have it at that time? Mr. Rolla, are the people satisfied with the factual basis?
Yes, Judge.
Mr. Trush?
Yeah, sure.
Mr. Rolla, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Trush?
I'm aware of none.
Mr. Rolla, are the people satisfied that the court has complied with statute? The court will own the taking of this plea.
We are, thank you.
Mr. Trush?
Defense is satisfied.
Mr. Paterka, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge, or both of these charges. The court will accept your guilty plea as to both. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. It's important that you stay in touch with Mr. Trush so that you're ready to go forward on that day. Before you leave court here today, you're going to meet briefly with Mr. Brunical here. He's the probation agent. So, okay. Thank you. Mr. Trush, Mr. Killen's case. Mr. Killing, are you able to hear me okay?
Yes, sir.
Thank you. We're on the record in People versus Joshua Killing, case number 226418. The record should reflect Mr. Killing is present today by video from Otsego County Jail. This was set for a hearing today on people's motion to use the prior testimony of the alleged victim in this case. I know that you filed a response early last week, on January 8th, I believe. I didn't get your brief in support of that until this morning.
And I didn't file it until this morning, and I apologize, Your Honor. I was given the notice of the hearing on January 3rd. Because of the holiday, because of Martin Luther King Day, it only gave me about 7 days to respond to it. I was out of the office sick on Friday when I had hoped to get it out. I was able to complete it and get it out this morning. I'm prepared to argue it. I have additional copies for the prosecutor and Your Honor, in case you did not receive it yet, or if the court wanted to hear it on a different date. I'm prepared either way.
Well, that's what I'm going to do, because this is, number one, as counsel both aware, this is kind of a unique situation. I'm not sure that there's a whole lot of case law that covers this exact circumstance. It's also a really important ruling one way or the other in this case, and I anticipate, and rightly so, that whichever way the court rules on this issue may end up being an appellate issue. So I think I need to read your brief. I don't want to go into this half prepared to rule on it. So Mr. Rolla, my intention would be to reset this for the court's next available date and proceed. Do you have any objection to that?
Well, Judge, in light of the fact that our office only received the written copy of the defendant's brief by, looks like, email, which came in this morning, I can't very well object. I mean, I can demand that we have the hearing today, and the brief wasn't found in time, but again, it's within the court's discretion to do as the court's already indicated. So I'm not going to waste the court's time arguing.
All right, thank you. So that's how we'll proceed. Mr. Killing, do you have any questions at all?
No, sir.
Okay. All right, thank you. That's all for this hearing today.
Thank you, Your Honor.
Lumber, are you ready with Mr. Swift's case? On the record in People versus Randall Swift. This is case number 236536. Mr. Rolla, I know that we have a couple of victims that want to join today by video.
Judge, we have apparently one here and one by video, as I've just been advised on my victims. Oh, I'm sorry, two by video. Okay.
Would that be Mr. Fockler and Ms. Fitchner.
That's correct, Judge.
Okay, I'm gonna let both of them in. Okay, if I could have counsel put your appearances on the record, please.
Thank you, Your Honor. For the record, McLoud.
Morning, Judge Elliott Blumberg on behalf of Mr. Swift, who's seated, but will be standing right now to my right.
And Mr. Swift, if you want to come right up to the podium there, please.
Yes.
Thank you. All right, this is the date and time set for a sentencing hearing in this matter. I did receive the sentencing memorandum from both sides. We had a chance to review those. We'll address Mr. Rola's scoring objections in just a minute. The court's also in receipt of a letter from Dr. Bobish at Alpine Cardiology. Had a chance to review that prior to today's hearing. So I think I've got everything that the party submitted. I've had a chance to review all of that as well as the pre-sentence report. Mr. Swift, have you had a chance to go through the pre-sentence report with Mr. Blumberg?
Yes.
Okay. Mr. Blumberg, other than what you have in your memorandum, and of course, I'll give you an opportunity to respond to the scoring challenges. But in terms of the body of the report, are there any additions, deletions, or corrections?
Yes, Judge, there are. On page, it's actually the second page of the report, says that Mr. Swift is represented by attorney Patrick Fragel. So obviously a mistake.
And Judge, we obviously have no objection to that correction.
Okay. And I guess I missed that one. Mine is corrected on the case page. Where's the other spot?
Yeah, I wrote it.
Okay, got it. Thank you. So that's in the evaluation. The next correction is to
In the one, the third full paragraph, I guess would be the fourth paragraph, where it says, Mr. Swift currently takes medication for depression and anxiety. That's incorrect. He has been prescribed medication, but does not take it.
So if we change, he is currently prescribed.
Yes.
Any objection to that, Mr. Rolla?
No, Judge, I think that would more accurately reflect what's going on.
Other than those two changes, Judge, I don't believe there's any other factual statements that are inaccurate.
Okay, and do you have any objections to the guidelines of the court?
We believe that the probation department is correct that the guideline range is from 5 to 23 months.
All right, thank you. Mr. Rolla, before we get to your scoring objections, do you have any changes that need to be made to the body?
Not to the body report, other than it's already been indicated and addressed on the record.
Okay. And so your challenges to the scoring, if you would address both OB1 and OB2, those are kind of related. Address those arguments for the record.
Yes, Judge, as to OV1, this is circumstance where factually as indicated in the police report and as reflected in the PSIR, the defendant attempted to pass another vehicle in a no passing zone with road conditions icy and snow covered, resulting in the defendant being unable to get back into his vehicle and hitting it, the vehicle in which the decedents were the occupants, killing them both. His blood tested positive for a scheduled controlled substance, that being tramadol, as indicated in Exhibit A attached to our sentencing memorandum. The defendant's blood had 114 nanograms per milliliter of blood of tramadol. Under OV1 pursuant to MCL 777.22, 5 points are to be assessed under 777.31, parent 1, parent C, where a victim was touched by any other type of weapon. In this case, unfortunately, to put it bluntly, the victims were not only touched by some other type of weapon, that being a motor vehicle in this case, they were killed by it. And as the court's well aware, items which are not normally considered as weapons are treated as weapons when they're used as weapons. In this case, the impact of the vehicle caused their death. So the people submit that 10 points, not 0 points, should have been assessed under OV1. As to OV2, at the court's request, I'll continue with that.
Yes.
Thank you. For the same factual reasons, under OV2, 1 point, not 0 points, should be assessed where an offender possessed or used any other type of potentially lethal weapon. We know it was a lethal weapon because obviously there are 2 people that were killed as a result of this. And pursuant to MCL 777.32.1C, 1 point at 0 point should be assessed.
Thank you, Mr. Plummer.
And Judge, I'm frankly astounded that the prosecutor is taking that position that this vehicle in any way could be seen as a weapon. This was an accident that occurred. He had no intention of running into the other car. He did everything he could to get back into his own lane. And as to the tramadol, that was a prescribed drug, which he's taken for months and months, if not years, for his arthritis. It's prescribed, and he took the same amount that was prescribed to him. So again, I think the scoring is accurate, and frankly, I just don't understand the prosecutor's position.
Okay, so I had a chance to look at OV1 and OV2 and the case law involving, non-typical items that have been viewed as weapons by courts in the past. And in reviewing those cases, it's clear to me that the most important consideration when determining whether a non-traditional item was used as a weapon for purposes of scoring, there has to be some type of intent to use that as a weapon. Based on the information that I read here in the report, while Mr. Swift's actions were reckless, certainly negligent, and there's any number of words that could be used for his decision to try to pass his vehicle at the time and place he did under the conditions that he did. The court can't find by a preponderance the evidence that there was an intent to use either the substance or the vehicle as a weapon, and without that proof of intent by a preponderance standard, I don't think it would be appropriate to score OV1 or OV2. Not that either of those things couldn't be used as weapons under certain circumstances. I just don't think there's an evidentiary basis for finding that they were used as weapons here. So the court will deny the challenges to OV1 and OV2. The next challenge is to OV3, and as to that one, Mr. Roll.
Thank you, Judge. As to OV3, the PSR is currently scored 25 points, which applies to, as the court's well aware, life-threatening or permanent incapacitating injury occurred to the victim. In this case, it wasn't life-threatening or incapacitating injury. In this case, it was that people actually died. Under that circumstance, it's 50 points that were properly assessed for the deaths of both Cynthia and James Faulkner. That's pursuant to MCL 777.331B. Because again, it's a circumstance where death results as the commission of the crime and the offense involves the operation of a vehicle, and the offender was under the influence or visibly impaired by the use of a controlled substance. Now, while the defense can make the argument that this is a prescribed substance, the statute does not distinguish between prescribed or non-prescribed substances. It distinguishes between controlled and non-controlled substances. Tramadol is and has been for a very, very long time a controlled substance. Now, whether the defendant used the amount he's supposed to and has been taken for a long time or not, I can't say. I can't look into his mind. I wasn't there. It is of some concern that, as indicated by the defense at the very beginning of this hearing, that although the defendant is prescribed medication, he does not take his medication as prescribed. That may very well be what took place in this state. That may give some explanation as to why an individual would not be thinking clearly to try and pass in a no passing zone under the icy and snow covered road conditions as existed, and tragically resulted in the deaths of 2 people.
Thank you, Mr. Plummer.
Judge, there is absolutely no evidence that the amount of tramadol that was in the system had any effect on his ability to think clearly, to make decisions, or to operate a motor vehicle. Again, it's the prescribed amount that he always takes. And the analogy or the comparison to his failure to take the antidepressant medication because it doesn't make him feel well it is really a stretch. And again, I'm just a bit taken back by the prosecutor's position. The reason he was originally charged with operating and being impaired by this, and that was dismissed because there was no factual basis to the charge. For him to be scored for 50 points is just really inappropriate. I think the probation department had it correct, and we'd ask the court to deny the request by the prosecutor in regard to that scoring.
All right, again, the court had a chance to review OB3 to look at the case law interpreting OB3 under circumstances similar to this. Again, I don't think there's a factual dispute that Mr. Swift had tramadol in his system. Certainly the court can make a finding based on the submission of the prosecutor by preponderance of the evidence that he did have tramadol in his system at the level of 114 milligrams or nanograms per 100 milliliters of blood. I think the real question here, of course, is whether or not he was under the influence or impaired such that he was unable to safely operate the vehicle. And whether he clearly didn't safely operate the vehicle. But whether that was due to poor decision-making or the influence of tramadol, I think the court would have to find again by preponderance of the evidence that it was based on being under the influence of or impaired by the use of that substance. When I look at the information I have to go on, which is what's contained within the pre-sentence report, there aren't any indications that the officers conducted any kind of field sobriety tests on Mr. Swift at the scene. There isn't any indication here in the report that the officers suspected or made any findings that he was impaired or under the influence. And so I think again, what the court is presented with is a lack of evidence for the court to base a finding under a preponderance standard that Mr. Swift was under the influence of or impaired by the substance at the time that this took place. So for those reasons, the court denied the challenge to OB3. That leaves us with the final challenge, which is to OB5, and that's to that one, Mr. Roller.
Judge, this one, with all due respect, I don't believe there can be any challenge. It's a situation where, as indicated in the victim's impact statement of the daughter of the deceased, that this matter so affected her, she had to and is still getting professional psychological help. Ms. Mishner stated, quote, personally, I have suffered severe anxiety and depression since the crash. I have had to seek professional help for these conditions as well as grief counseling. And prior to these statements, Ms. Mishner also indicated the same partake that spreads through the rest of my nieces and nephews who are the grandparents, and I won't be able to make any more memories of them. As the deaths of her parents so emotionally harmed the daughter to the extent she had obtained and did in fact obtain and is still obtaining professional psychological help for anxiety and grief. 15 points should have been properly assessed and voted pursuant to MCL 777.351A. Thank you.
Thank you, Mr. Wilbur.
Judge, we're really not in a position to question or challenge the psychological damage that may be experiencing by family members. Clearly, they are victims under the statute. I guess I don't know why the probation department scored it the way it did. I really can't quarrel with the prosecutor's position in regard to that.
All right, I did review OB5 as well as the statute regarding the conviction here, which is reckless operation causing serious impairment. And that is a crime against the person, which means OB5 is scorable. I think there's more than adequate evidence in the record to support a finding that family members of the victims in this case have suffered serious psychological injury to the point that requires treatment. And I think scoring of 15 points under OB5 is appropriate. So the court will score OB5 at 15. That raises the OB score to 60, which also raises the level from 4 to 5 and results in a scoring of guideline range of 7 to 23. Mr. Rolla, do you agree with that?
That's correct, Judge.
Mr. Blumberg?
I do.
Okay, thank you. Mr. Rolla, any further challenges to the scoring?
No, Your Honor.
Okay, and did you say that there is someone here in the courtroom that wants to speak?
No, it's two people by video. I originally understood one of them. Oh, there, again, no, I was correct, Judge.
Okay. We have
My
somebody here.
apologies. We do have.
Mr. Blumberg and Mr. Swift, if you would have a seat at council table there, please. Thank you, sir. If you come right up, yes.
We do have one who appeared by video as well.
Okay, thank you. Sir, can you tell me your name, please?
Yeah, good morning, Your Honor. My name is Sean Winter.
And what is your relationship with the victims?
I'm the son of Jim and Cindy Blockler and the oldest.
What is it that you would like to say here today?
Yeah, thank you. First and foremost, I'm here speaking for myself, not in any official capacity of my siblings or my family, just sharing my thoughts. I know my sister has shared hers with the victim rights advocate, and I have both my brother and sister on the call today. I'll try to be brief. I'd want to be succinct and have this written down beforehand. I just couldn't bring myself to do it. One of the reasons is throughout this tragedy, I've come to learn that it's not a singular event that you experience, but it's one that you actively live every day. And so it's just a burden to sit and do that. So instead, I jotted these notes on the car ride up today. Here we are 13 months later, again, taking a day off of work to physically be present and live this experience. So on Thursday, December 15th, 2022, my parents were on their way to my brother's house. They were going to spend the afternoon with my sister-in-law, who was on bed rest. She had a very complicated pregnancy. She'd been hospitalized a number of times. And while my brother was at work, they were going to spend the time with her. That afternoon, I was getting messages from my brother. If I'd heard from them, they hadn't shown up. Once I got out of a meeting at work, he called me and I was on my way to an appointment. And he said, I think you need to cancel that. I'm on my way over. Something didn't feel right there. So instead of my parents showing up at my brother's house to be with my sister-in-law, it was a Otsego County deputy to let her know what had happened. They then both drove together to my brother's place of work to let him know. And then he came to my work to let me know. It was at that point that I gave my sister a call, you see, but that was also her birthday that day. So that was not the call that she expected. She was at the zoo in San Diego, and I remember her just hyperventilating on the phone. So from that point, it was a cascade of trauma and grief that we've experienced throughout this. It's not just an event, but a lived experience. So, that Saturday morning, my wife and I and brother, we went to their house. It was obvious when we walked in because we went to see if everything was okay. For all we knew, a crock pot was left on or something. And it was clear they had planned to come back. Death was not in the cards that day. My dad's half-finished coffee cup was beside his chair. There was a plate of cornbread on the stove and their breakfast dishes in the sink. The Christmas lights were on. The gifts for the grandkids were under the tree, waiting to be wrapped next to the paper. Clothes in the dryer, ready to be folded. On the fridge was all the art from the grandkids, their pictures, the to-do list, always a to-do list. But we were able to grab their ham out of the freezer, have it for Christmas that year. But then it just continued. We had the experience. We had to go to the funeral home and see their bodies laying there on trays, clearly dead. The second you see a dead person, they didn't look normal because of the physical trauma, the accident, from the impact, the organ donation. It's the last physical image I have of it. It's forever seared in my memory. It's something that haunts me at night as I try to fall asleep. We had to order their cremations, going back to the funeral home and pick up their belongings from the accident. My brother and I had 2 bags that we opened at his house. Inside of it was their wedding rings, my dad's dentures, his cell phone he carried in his breast pocket, shattered. Their clothes destroyed, having to cut off their bodies. They were still wet and red with blood. I remember turning and just vomiting in his driveway. We gathered it up and burnt it all in his backyard. Later, once the investigation ended, we went to see the car here in Otsego, partly for closure, but just to understand. And seeing that car, it made sense. It's hard to wrap your head around 2 people dying instantly, but there weren't many questions after that. There's blood on the seats. My dad's boot's still on the pedal. I was able to grab my mom's glasses. They were broken, but they sit on my nightstand. I have them today. And it continues. I had to go through the invasive process, digging through all their belongings, trying to figure out their affairs, setting up estates, dealing with attorneys and insurance companies, all the appointments that come with the business end of death. I had to go back and pick up their ashes, their last physical presence reduced to a white powder and a wood box on a table. I had to write their obituaries, plan 2 funerals, set them up, find the location of the accident based on the police report, walking the shoulder until we found all the glass and plastic, and realizing that's where it had occurred. Have since been able to set a roadside cross there. Still continuing the process of emptying their house, trying to mentally distinguish between stuff versus memories. It's become a second job that It's one that we've all been forced to take. And of course, after the accident, we're all the first. Christmas last year didn't count. I don't think any of us could really fathom what was happening. It was all numb. But 1 month and 4 days later, that grandson was born. They weren't there for him. He was named Hamish, which is Hebrew for James, my dad's name. 1 month and 12 days later, I had my first birthday ever not seeing or hearing from them. Exactly 2 months later, my dad's 70th birthday was missed, as well as my parents' 37th anniversary. This was followed by Easter, my daughter's birthday, Mother's Day, Father's Day. July came. My brother married his now wife, but instead of my parents being at that wedding, there was simply a photo and 2 burning candles in the front row. And on until here we are today. I think the hardest part for me is them not being able to see their grandkids grow up. They were robbed of that. Parents often invest so much in their own children. It's such a gift to get back to them. The product of that is bring up the next generation. And in turn, those sweet grandchildren have been robbed of a full and rich life with those grandparents. I too, as was mentioned earlier, suffered quite a bit of mental and emotional distress. I have therapy, so going, counseling, medication. I've had various procedures, time and experience robbed from us. This in turn has had deleterious effects on my physical health, relationships, my profession, etc. And of course, a less impactful way, there's the very expensive side of death that also has to be dealt with. And I get it, Your Honor, grief and loss is a part of life. Where I'll always struggle is their loss and our suffering was all preventable, and it shouldn't have been this way. So as hard as it has been, all of this, the hardest part, though, for me is having to forgive Mr. Swift. This is something that my faith compels me to do, but moreover, I know if I can't find a way to do so, it'll destroy me from the inside, and this domino effect will just continue that I've lived rather than healing. And I feel pretty confident that that is not what my parents would have wanted. So, but forgiving isn't forgetting. Crimes were in fact committed, and so justice is due, which is why we're here today. On the topic of jail time, Your Honor, I don't have much to offer. I personally and philosophically struggle with our system of incarceration in this country. I don't see how it always helps rehabilitate people or the benefits it brings to society. Furthermore, a prolonged sentence has the potential to create a loss for the defendant's family, similar but to a much lesser degree than ours. And it's not fair to make them suffer. They did nothing wrong. And at the end of the day, their suffering will heal my suffering. And at some point, that ripple effect has to stop. I know he'll have to live with this for the rest of his life. And it's not that I don't think jail time is appropriate. I don't have anything to offer in that regard. I'll defer to the justice system to use their equations or whatever it is that they use to determine what amount of time may be equal to 2 human lives. But after much wrestling, I've come to accept that the defendant did not make a purposeful choice to kill my parents. However, a choice was made. To accept that he made that purposeful choice to kill my parents, I would have to forgive any hope of humanity that I have, and I'm not there. And if the defendant hadn't made that choice, my parents would still be with us. I wouldn't have taken the day off again to be here like many other days. The grandkids would have just spent another wonderful Christmas with them. Another hunting season would have passed with more memories made. And that's the point I want to emphasize today, Your Honor. A choice was made while exercising a privilege that resulted in 2 deaths and all the associated suffering. That privilege is the privilege of driving, which is not a right, since the defendant, in this instance, has demonstrated that his choices and decision-making while exercising that privilege puts others in harm's way, or worse yet, in our case, results in death. I ask that the court revoke that privilege. And whereas my parents' death and our loss and suffering are the result of his choices that we will live with forever, I ask that this privilege of driving also be revoked forever. It's one way to prevent the defendant from making that choice again and causing more suffering. In this regard, a permanent revocation of driving privileges would yield greater benefit to society through prevention of a repeat incident than any number of months of jail will provide. Again, not that jail time isn't warranted, but keeping the defendant off the road so this doesn't happen to another family is really the only form of justice this court could deliver. Yet I acknowledge it can't undo what's been done. Thank you, Your Honor.
addressing the folks that have joined in remotely. Ms. Mitchner, did you wish to make a statement? If you do, I just need you to unmute.
Yes,
There you go. Ma'am, did you want to make a statement today?
yes, thank you, Your Honor. Can the court hear me?
I can. Can you just tell me your name and your relationship here, please?
Yes, my name is Heather Mishner, and I'm the daughter of Jim and Cindy Faulkner.
Thank you. What is it that you would like to say today?
Thank you, Your Honor. As you mentioned, I had already submitted a victim impact letter to the court, and I understand that you did have a chance to read that. I'm not going to read that statement, the entire statement in front of the court this morning. But I do just want to take a brief moment just to stress again, just how absolutely devastating this ordeal has been to me and my family these past 13 months. The reckless, careless actions of the defendant that horrible morning took our parents from our world in an instant. And I understand, that it wasn't intentional. That outcome wasn't intentional. But as my brother mentioned in his statement, that choice was made, passing in a no passing zone, in horrible snowy conditions, solely led to the death of my parents. My brothers and I visited the site. We stood in that spot, saw that curve, how blind and big that curve was. It was just shocking that anybody under any circumstances would try to pass around that. The two people, my parents, that were killed in this accident were so incredibly full of life, just starting retirement, just starting their dream of moving back to northern Michigan, where we're from, so they could be close to their grandkids and watch them grow up. They were incredibly loved by everyone that knew them, including their children, myself, my brothers Sean and Josh, grandkids, countless nieces and nephews, brothers, sisters. My dad's mother, our grandma, is still alive and has to go through this ordeal at 90 years old. Many friends, dear friends of theirs, both in Michigan and in Florida where they used to live. Everybody is suffering greatly from this ordeal. We will have to live with this pain, this agonizing pain of their absence and the devastating way they were taken from us so suddenly for the rest of our lives. That being said, I just want to say that it is my sincere hope that the defendant is never allowed to drive again, because anyone that is willing to drive so carelessly and recklessly should not have the privilege to drive, so that this can never happen to another family or another person. I think that's all I just wanted to add in addition to my statement letter, Your Honor. Thank you for the opportunity to speak.
All right, thank you. And then we had one other individual, Mr. Faulkner, did you wish to give a statement? If you do, I just need you to unmute, please.
Yeah, I'd like to say something. I don't know if you all can hear me. I'm riding passenger in a vehicle right now at work. But is the background noise too loud?
Nope, I can hear you just fine. And can you just tell me your full name again and your relationship here as well, please?
Yeah, I'm Josh Faulkner. I am the son of Jim and Cindy Faulkner, the youngest.
Okay, thank you. What is it that you would like to say today?
I just want to really kind of go off of what Sean and Heather already said, that driving is 100% a privilege. And when you make a careless decision such as the defendant had made, I really do hope that above anything else, the driver's license is suspended for the rest of his life. I just, making such a poor judgment and causing the death of 2 people on a road that is driven all the time, you know, really just hopefully is made unavailable for him to make ever again. As Sean was kind of touching the jail time. Yeah, what is that really going to do though? You know, also there has been a lot of life events. The unfortunate thing is when people die, life goes on, and we're here having to do everything without them. One of the hardest things for me is when I'm driving. That's when I used to call my dad. I don't get to do that no more. Hunting season really kind of sucks now. I mean, that's what him and I always did. And then just my child. Every time I look at my child, all I can think of is my mom and dad not ever being there or ever meeting him, and how they were, or how Hamish was completely robbed of their presence. Also, I have a 6-year-old daughter that will probably not remember them and is already kind of forgetting them. My son, he is experiencing trauma like none other. He can't sleep at night. He's going through counseling, and I'm referring to Emerson Faulkner. He's just in constant agony and in counseling and all sorts of other things because of this, because that was his best friend. So, this all being said, it's really unfortunate this happened. I understand accidents happen, but in this case, this is 100% poor judgment. I wouldn't classify this as an accident, in my opinion. But anyways, there's not much I can say. I am with my brother in the fact that I am seeking in my heart how I can forgive the defendant. But it's hard just because of the poor lack of judgment. That's really all I have to say. Thank you.
All right, thank you. Any other victims, Mr. Rowland?
No, you're wrong. Thank you.
All right, anything you'd like to say on behalf of the people for Valley Commission then?
Just briefly, thank you, Judge. No one here, prosecution specifically, are indicating that the defendant got up in the morning of this incident and said, I was going to go out and drive and kill somebody. Nobody thinks that that's what happened. We think this was, to use the victim statements, poor judgment. Yes. Again, it's people's position that that poor judgment may or may not have been, we think was have impacted by the defendant's perhaps misuse or non-prescribed use of his medications. We don't know why someone would make the decision to pass under the circumstances which to any normal individual would have immediately said, this is not where I pass. Those are the conditions we have. So something affected his judgment. Now, I understand the court's position, and again, I'm not here to argue that point. If the police did not do sobriety tests because of the nature of the accident, the injuries and everything else, the focus was on trying to get people help that may have needed it and get the accident cleared. This wasn't focused on specifically being your regular drinking and driving stop for the else. As painfully set forth in both the victim's impact statement and also in the statements the courts heard from the other victims this morning, the defendant's needless actions affected numerous lives, not just the lives of the two decedents, but their families, as the courts now heard somewhat extensively, including one life that had not yet even come into this world at the time that that child's grandparents ceased to exist. This isn't one where the people are saying the court should send the defendant to jail for an extended period of time. I don't know that that's going to help. Obviously, you can't undo what's done. But as far as the license sanctions, the court's well aware by statute there is impositions that have to take place. The court can do more with that. I leave that up to the judgment of the court. Thank you.
All right, thank you. Mr. Blumberg, if you and Mr. Swift would come up to the podium. Mr. Blumberg, anything that you'd like to say today on behalf of Mr. Swift?
Certainly, Judge. Certainly the loss must be unimaginable for the family. I mean, it was a tragedy that took place. In regard to my client's driving privileges, that's already been addressed by the Michigan Secretary of State. His license has been revoked except for purposes of going to medical treatment and coming to court. So he will never have a full driving privilege again for the rest of his life. As I pointed out in my sentencing memorandum, I have to believe that this case causes the court at least some emotional dilemma in terms of needing to, in some extent, punishing Mr. Swift for his actions, but yet taking into consideration his entire life of following the law, of having no prior criminal record, being a Navy veteran. And by the way, another sanction that is necessarily resulted from his conviction in this matter is he will lose all of his veteran benefits. Not that his loss or his punishment in any way diminishes from the poor decision-making that he made. But here's a man who's 69 years old, has congestive heart failure, has all sorts of medication that he has to take on a daily basis to stay alive, and has cancer. So the dilemma, Judge, I see, at least from my perspective, is how do you balance, how does the court take into consideration the reckless action that he took one time in his life, a tragedy for certain. And he lives with this tragedy every day, and his concerns and his anxiety is certainly different from the loss that the family must have experienced. And again, Mr. Swift, in his own way, will attempt to apologize for the decision-making. But Judge, I think you need to take into consideration where Mr. Swift is in his life and balance that against one day, one act of carelessness that has forever changed the life of the victims, but also him and his family. The recommendation that was made by Ms. Rhodes, who actually prepared the pre-sentence report, talks about the court, if it is going to impose any jail time, to look at the lower part of the sentencing guidelines. We've asked the court in our sentencing memorandum to consider some alternative to incarceration. Certainly home arrest or on an electronic tether, I think that will only allow Mr. Swift to go to his doctor's appointments, would be a balanced decision, a balanced sentence that the court could follow. Certainly the fines and costs and the restitution required is all appropriate. I'm just sincerely asking the court to consider the alternatives to jail for this man at this point in his life. Again, I've offered the court two alternatives, and we'd ask the court respectfully to consider those.
Thank you, Mr. Swift. Is there anything you want to say today?
Yes, sir. As God is my witness, I never meant for any of this to happen. And if he would take my life today to make it better, I'd let him without question. But there's nothing I can do. And losing my life on top of the horrible tragedy that these people had to face, and I will always live with it every day I see it. But as God is my witness, he could have my life this second if I could change it. I can't. And that's it. So.
All right, thank you. I did have a chance to review the report in this case. And so I take into account all the information in that report, along with written submissions from both the lawyers in this case. Certainly I take into account the statements that each of the victims has made here this morning. Mr. Faulkner, I can't quite see you, but I do want to thank you for getting up and making the statement that you made, as well as your other brothers and sisters. I always think it's important for victims to address the court at sentencing. It's not an easy thing to do a lot of the time because it brings up a lot of those feelings and emotions that you've been dealing with and puts them right front and center again. And that's hard to do. And it's hard to do in front of a room full of people as well. And I appreciate your statements, all of them, because number one, it really gives me an insight into what all of you went through as a result of this. And, you know, your description really, it paints a vivid picture of what that must have been like for all of you. And I'm sincerely sorry that you all had to go through that. And I also think it is a really good example of kind of the competing feelings that I think victims go through between wanting to forgive, finding that a hard thing to do, wanting to see punishment, but also understanding how does that fit into the big scheme of things. And I think all three of those of you that spoke here this morning did a good job of kind of outlining what that's like to go through. So thank you for your statements. It is, Mr. Bummer, you're exactly right. This is an absolutely difficult case. This is the most difficult case for any judge to try and balance all the different interests here. And there are a lot of different interests. This is the kind of circumstance, I don't think there's anybody who's ever driven in their life that hasn't been in a position where you're running late, you need to get somewhere behind a car that's not going fast enough for you, not necessarily going fast enough, but not fast enough for you. And wanting to get around that car and get on with your day. And one of the biggest responsibilities we all have as drivers, and I don't think any of us probably think about it enough, this situation certainly highlights it, is when you're going to make that decision, pass a vehicle or whatever decision you're going to make on the roadway, you really have to think about, what is this going to do? Is this a good spot to do it? And what's the worst thing that's going to happen if I try this at this point? And this is a great example of how that can go wrong in an instant, and how a common decision that's made every day, thousands of times on the roads of our state, can instantly result in a really tragic death of two people. I don't think anybody's saying, Mr. Swift, that you intended this to happen. I didn't hear that from the victims at all. But I don't know that excuses your actions, that you didn't intend it to happen. Because you did make a decision that day, and you made it primarily with your interests in mind and not with the interests of other people on the road at that time. In terms of what kind of punishment, you know, the court has to look at a number of different factors here. What is the rehabilitative aspect to this? Mr. Swift, I'm confident looking at your record. Everything that Mr. Blumberg pointed out is correct. You lived a law-abiding life. I have to think that you've been pretty responsible with most of your decisions. Otherwise, you wouldn't have gotten this far without having any issues. You served your country for honorably discharged. There's a lot of things that provide mitigating factors here. But the court also has to look at your conduct. And there are some mistakes and some decisions that carry with them much more heavy consequences than others. And when you make a mistake that carries with it the kind of consequences that resulted to these two innocent people on the road, that carries with it serious consequences for you as well. Your health concerns certainly are a factor, but that's not something that I can solely base my decision on, because ultimately you put yourself in this position. The guidelines in this case call for up to 23 months in prison. I don't think that's appropriate, but I do think there needs to be a consequence here, not just for you, Mr. Swift, so that you understand that this was a serious error and serious lapse in judgment that you made because of the consequences, but also so that other people who are out on the road understand that this is, it is a very great responsibility, even though we don't always think about it that way. And for the purposes of deterrence, people have to understand that roads are a dangerous place, and decisions that you make while you're driving every day can have life and death consequences. So I think a sentence in the middle of the guidelines is appropriate. I think it recognizes the mitigating factors here, but I think it also recognizes the seriousness of the error in judgment and the seriousness of the effect that it had on the two people who lost their lives as a result of this. That's not to say that the court isn't going to provide for you to be able to attend medical treatment. If you're in a position where your health is immediately endangered, the court will grant you a furlough. But I do think some jail time is appropriate in this case, and I think it's reasonable and it's justified by the circumstances. The court is going to sentence you to 12 months in the Otsego County Jail. You have credit for 1 day served. Again, to the extent that that you need to attend medical appointments, the court will allow you to be released for those medical appointments. If, again, at some point, there's some type of emergent circumstance, the court will grant you a furlough to be released from jail if you need medical treatment, or if your health is in a position where your life is endangered. But other than that, you will be required to serve that time in jail. The court is going to place you on probation for a period of 24 months as well. The court's going to adopt as the conditions of that probation all the terms and conditions listed in the report. The court is going to order restitution in the amount of $7,638. That's to be paid to the Otsego County Clerk to be dispersed to Sean Winter. A crime victim's assessment of $130. Supervision fee while you're on probation of $30 per month. $325 court costs. DNA testing fee of $60 and a $68 state cost. Court is also going to order the permanent revocation of your license to the extent that the court has the authority to do that under statute. I do think, I mean, you were driving to attend medical treatment in this circumstance. So in my view, a restricted license allowing for that is not appropriate. To the extent that you need to attend medical treatments, you're going to need to find somebody who can take you to those treatments. You do have the ability to seek an appeal of this sentence, and Mr. Blumberg, if you could provide those appellate rights to Mr. Swift, and you can let me know once he's initialed those to acknowledge receipt.
Your Honor, for the record, Mr. Swift has executed by placing his initials on his notice of right of appellate review.
All right, thank you.
I would make one last request, if you could, please.
Yes.
Mr. Swift has lots of medications that he has to get together. Would the court allow him to report to the county jail on Friday?
He needs to report right now. That's my usual practice, and I don't want anything to happen between now and Friday. So he needs to report now. He can find somebody to make arrangements to get his medications.
Do you go?
Yes.
What's up? It's gonna get some.
Could I say something? Probably won't work. Would that be all right? If I talk to my wife?
So you can come up here.
Is this necessary?
It's just practice.
See ya.
Is this matter concluded?
Yes, thank you. All those related to this case are free to disconnect. That's the end of that file for today. Mr. Blumberg, is your client appearing remotely for this hearing?
I don't know if she is or not, we can do it without her.
I don't see her connected.
Yes.
That's the name of the criminal docket.
I still have the 4D child support matter at 11:30 then, Judge. I understand you have some matters before then.
Oh, got it. Yeah.
So with the court's permission, I'm going to leave for a few minutes, speak to the victims, and then I'll return to the court.
Sure. Yes.
Thank you.
All right, Mr. Garfield, are you able to hear me okay?
Yes, I am, Your Honor.
All right, we're on the record in Glazier versus Glazier. This is case number 23-19311. We have Mr. Blumberg present here in the courtroom on behalf of plaintiff Beth Glazier. Mr. Garfield's present by Zoom on behalf of defendant Travis Glazier. I do see Mr. Glazier connected. This is set for a status conference today. Please, Mr. Blumberg, can you tell me where things are at with this file, please?
Yes, Judge. Mr. Garfield kind of got into the case a little late, so we were scheduled to go to mediation. We couldn't complete it because the financial information that we needed had not yet been provided. So we still are waiting for that information. We understand that Mr. Glazier is in rehab right now, so I don't know whether Mr. Garfield has access to the financial information that we requested. But we are scheduled to go back to mediation, and so that's where things are kind of at this point.
Okay, Mr. Garfield?
Yeah, Your Honor, we did have to reschedule. We have all the personal stuff on our end done. Waiting for a few of the business financials and a list that Mr. Blumberg provided us that he wanted. So I would say a 30-day recess, we'll have that mediation within 2 to 3 weeks and maybe a follow-up after that if needed. But we're kind of back on track. Travis is out of the rehabilitation and he's going to be starting into drug court. So he has access to the records at this point.
Any objection to that, Mr. Blumberg?
Was he suggesting that we have another status conference in 30 days?
I think so.
I think 45 days would probably be more appropriate.
Okay,
I would
any
agree with
objections?
that also.
Okay. All right, so we'll set it for a status conference in about 45 days. Mr. Blumberg, anything else I can address for your side today?
No, Judge, thank you.
Mr. Garfield, anything further on behalf of your client?
No, Your Honor.
Okay. Thank you. That's all for today. Mr. Garfield, you and Mr. Glazier are free to disconnect at this time.
Thank you, Your Honor.
Did you have any other family matters here today, Mr. Blumberg?
I don't think so, Judge.
Thank you. All right, Ms. Stanco, can you unmute yourself, please? Thank you. Are you able to hear me okay?
Yes, sir.
All right, and Mr. Dibble, if you can hear me, I need you to turn on your camera and your microphone, please.
Yeah, I can. Yes, sir. I can hear you. I'm trying to start my video. There we go.
Okay, thank you. All right, we're on the record in Dibble versus Stanco. This is.
I'm so sorry. I'm so sorry.
This is case number 2319454. Both parties are present here by video. I I do have this set for entry of a judgment of divorce today. Mr. Dibble, is that how you wanted to go forward?
Yes, sir.
And Ms. Stanco, is that how you wanted to proceed as well?
Yes, sir.
I'm going to place you both under oath. I've got some questions that I need to ask each of you. The questions I'm going to be asking are those that I'm required to ask to establish the grounds for divorce under Michigan law. So if you would please both raise your right hands. You both solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Thank you. You can both lower your hands. Mr. Dibble, as the party filing in this case, most of my questions here at the beginning are going to be for you. Mr. Dibble, at the time that you filed the complaint and signed that complaint, had you been a resident of the state of Michigan for at least 180 days?
Yes.
Had you been a resident of Otsego County for at least 10 days?
Yes.
In the complaint for divorce, there's a statement that indicates that there's been a breakdown of your marriage relationship, such that the objects of matrimony have been destroyed and there remained no reasonable likelihood that the marriage could be preserved. Was that true when you signed the complaint?
Yes.
Does that remain true today?
Yes.
Are there any children under the age of 18 that were born to or adopted by you during the marriage?
No.
In the proposed judgment of divorce, it indicates that you are not going to receive any spousal support. You understand that you would be waiving that forever and that you would not be able to come back later and ask the court for that.
Yes.
And you have included with the proposed judgment some specific property division provision. So you are going to be keeping the 2011 Jeep Sport and you're going to be responsible for any debts regarding that vehicle. Is that correct?
Yes.
Okay. And you own some property on Richland Drive in Johannesburg, and that is going to be awarded to Ms. Stanco, and she will be responsible for any debt associated with that property. Is that correct?
Yes.
Okay. And otherwise, you both have agreed on how to divide up any other property and there remain no issues for the court to decide?
No, sir.
I'm sorry, you broke up there. Could you repeat that?
You're correct. Yes, sir.
Okay, thank you. All right, Ms. Stanco, were you able to hear all the questions that I asked Mr. Dibble?
Yes, sir.
Were you able to hear all of his answers?
Yes, sir.
Do you have any reason to believe that any of the answers he gave were untrue?
No, sir.
Are you currently pregnant?
No, sir.
Under the proposed judgment of divorce, you also would not be receiving any spousal support or alimony. You understand that you also would be waiving that forever and you would not be able to come back later and ask the court for that.
Yes, sir.
And did you hear my statements regarding the proposed property division?
Yes, sir.
And do you agree with all of those?
Yes, sir.
Okay, thank you. The court finds that the statutory grounds for divorce have been met by the testimony of both parties. I've reviewed the proposed judgment of divorce. It's equitable. It contains all the provisions required by statute. The court will grant the divorce and I've signed that judgment. If either of you need a copy of that, you can get that here at the clerk's office for your records. Mr. Dibble, did you have any questions at all?
No, sir.
Ms. Stanco, did you have any questions?
No, sir.
Okay, thank you. That's all for today. And you're both free to disconnect at this time.
Thank you.
Thank you.
person on the phone with the last four digits, 2622. Can you tell me your name, please?
Hi, yes, it's Jason Corby.
Mr. Corby, if you can just remain on the line for a minute, please.
Okay.
All right, ma'am, on the iPhone, can you unmute for me, please? Thank you. Can you tell me your name?
Lindsay Sevener.
Sevener. Okay, we're on the record in Corby versus Sevener. This is case number 1415238. We have both parties connected to this hearing remotely today. Back in November, the court referred this parenting time dispute to mediation. I did get a report from the mediation indicating that the parties were not able to reach an agreement. Mr. Corby, from your standpoint, is that correct?
Yes.
And Ms. Sevener, is that correct from your standpoint as well?
Yes.
Okay, so the next step is for the court to set this for an evidentiary hearing. That means the court will take testimony from both of you on this issue, and also to the extent that either of you wanted to call any witnesses that would be relevant, you would be able to bring in some witnesses to testify, and then the court will make a decision. Mr. Corby, do you have any sense of, aside from yourself, whether there would be any other witnesses you would want to call?
I mean, I guess not besides my wife, or that's probably it. I guess firsthand is my wife, or maybe his grandma, or.
Okay. Ms. Sevener, how about you?
I mean, I didn't think we need witnesses, maybe just our son, since it's only about parenting time. I mean, I guess I will get some if Mr. Corby will as well.
Well, neither of you has to call any witnesses. It's the court's going to have to make the decision on parenting time based on the best interests of the child. So, I mean, usually the relevant people are just people that have been around you during your parenting time, that could testify to, kind of what typically happens and so forth, but you can each do that yourself as well. So I guess to answer your question, Ms. Sevener, it's, I'm not requiring you to call witnesses or asking you to call witnesses. That's kind of a decision that's up to you.
Okay.
And I don't need to bring anybody either. If it's gonna, I just thought you were asking me if there's anybody that would, want to be there, or I need to be there, but.
Yeah. Okay. How old is the child in this case?
He's 11. He'll be 12 in April.
12. Okay. What's his school schedule like? Does he go to public school, or is he in a private school or homeschooled?
He goes to GIS.
Okay. All right. So he's of an age that the court certainly would consider his preference. So typically what happens is before the hearing starts, I would ask to have him available, and usually it's it's a grandparent or an aunt, uncle, or family friend or somebody that would bring him in. The court would talk to him in chambers outside the presence of both you and both parents, but with the court clerk present, so that the court can, the idea behind that is so that the child doesn't feel any pressure with the parents right there watching, you know what I mean? And so that would be a brief interview, and then he could go right back to school. So I think in this case, given his age, that would be a idea, so the court will put that in the notice of hearing as well, that he's to be available, 15 minutes prior to the hearing. If for some reason at whatever date it's scheduled, if that's a problem for his school schedule, we can work around that as well. But the court will send out notice of the date and time of the hearing. I'm going to set it for a 2-hour hearing. I think that'll be enough time. And then the court will make a decision. Mr. Corby, do you have any questions about that process at all?
No, sir, I don't.
Ms. Sevner, do you have any questions about that?
No, I don't.
Okay. All right, so we'll send out notice of the date and time of that hearing. And that's all I have for today. You're both free to disconnect at this time.
Okay, thank you.
All right, thank you. Thank you.
It looks like Miss Cotti Patty is joining us now. Ma'am, if you could unmute, please.
Yes, sir.
Can you tell me your name?
Janine Cotti.
Versus Ensing. This is case number 2319467. The record should reflect Ms. Cotti's presence today. By Zoom video, Mr. Roll is here on behalf of the state in person in the courtroom. And this is set for a consent judgment affiliation. You have proposed judgment, Mr. Rowland, and the state.
Just very briefly, Your Honor, the parties have signed it, it's been signed by the Supreme Court, and I think the court takes some very brief testimony from Ms. Cotti, and that she believes this is in the best interest of the minor child, and that the court should enter the judgment.
All right, thank you. Ms. Cotti, you are the biological mother of Cole Jacob Cotti, is that correct?
Yes, Your Honor.
And this proposed judgment affiliation establishes Jonathan Ensing as the father. Is that your understanding?
Yes, sir.
Okay. And this judgment would also provide that you would have sole physical custody of Cole and joint legal custody with Mr. Ensing and parenting time as the two of you agree. Is that your understanding?
Yes, sir.
And it also provides for payment of child support by Mr. Ensing on behalf of Cole of $474 per month. Is that your understanding as well?
Yes, sir.
As the mother of Cole, is it your opinion that entering both of those orders today would be in your child's best interest?
Yes, sir.
Okay. All right, based on the statements of Ms. Cotti here on the record today, the court also indicates the record should reflect that Mr. Ensing was provided notice of the date and time of today's hearing. He did not appear either in person or remotely. The court finds it is in the best interest of the child to enter both orders. The court has signed both. And Ms. Cotti, if you have any questions, you can contact the prosecutor's office, okay?
Thank you, Your Honor.
Mr. Roll, anything further for the record today?
No, Your Honor, thank you.
Thank you, Ms. Cotti. You're free to disconnect at this time.
Thank you.
Counsel, put your appearances on, please. Mr. Hellman, are you able to hear me okay?
I can hear you, Judge.
Okay. You're appearing on behalf of Mr. Ingersol.
Yes, Your Honor.
And Mr. Cadat, you're appearing on behalf of Ms. Ingersol. Is that her there with you?
Yes, I'm appearing on Cassandra Ingersoll's behalf, and yes, she is sitting near me.
Okay, thank you. We're on the record here today for a status conference in this case. And it looks like, Mr. Cadat, you've also filed a motion for entry of a default judgment of divorce. Mr. Hallman, did you receive that?
Yes, Your Honor, I did, and if I may, I had a chance to talk to Mr. Cadat this morning just to fill the court in on a little of the detail. My client and I, as the court knows, I'm representing my client for some of the criminal allegations that involve the parties in this matter as well. We had some miscommunication between my client and I, is all I will say, regarding whether we were going to represent him for this case as well. I asked Mr. Cadat if we could have a little more time regarding the terms of the divorce judgment, regarding not the term of divorce. My client does not object. He actually filed, he is the initial plaintiff in this matter, and the terms that counter defendant or counter plaintiff Cassandra Ingersol filed for were filed in a counter complaint. Anyways, Mr. Ingersol is still in federal custody. He has been since September. I have, like I said, we had a little bit of a miscommunication regarding our role in representing him. And then, as the court is aware, I was kind of out sick for like a month, basically, over the holidays. I would like some more time. I think that my client would agree that the term of divorce itself, he does not object to. It's just the desire that the counter plaintiff has with regard to some of the personal items, which, again, he doesn't really object to. He just would like to work things out amicably and stipulate rather than have the matter defaulted against him.
Thank you. Mr. Cadat?
So, Your Honor, we would like to proceed with the motion to enter the default judgment of divorce. And in particular, in addition to the compelling incentive of my client having been beaten by the plaintiff and counter defendant and the parties already having intact custody orders through a DC case in this county, we need to have this resolved also for the personal property aspect of things. There's a jointly owned and jointly indebted Harley-Davidson motorcycle that is going to be repossessed within the next few days if payments aren't made. And under the terms of this proposed default judgment of divorce, we're giving Mr. Ingersol the opportunity to try to remedy that situation and refinance it into his own name. We really, for the benefit of my client's credit, we need to get things finalized so that people can move along and try to mitigate their losses at this point. Delaying the entry of the judgment will just delay and create a longer period of time during which my client's credit is destroyed because Mr. Ingersol has not been making the Harley payments.
And Your Honor, to address the Harley payments, my client has made some payments. I believe that Ms. Ingersol has also made some payments. I think that the proposal made by the counter plaintiff in this matter makes sense. I think that my client just needs a little bit more time than 30 days to refinance the matter, or to refinance the Harley in particular, just because, again, he's incarcerated still, and no one was under the impression, and even when this motion was filed, that I don't think that Mr. Ingersol would still be in federal custody at this time. There's also other, counter plaintiff is seeking 5 the possession of 5 safes, which are allegedly in the possession of Mr. Ingersol's ex-wife, which, you know, that's on this default judgment. And Mr. Ingersol is, again, he's not contesting that he wants to help this divorce through. He would agree that to the prospect to the term of divorce. It's just all the other terms that you know, counter defendant is seeking, or counter plaintiff is seeking, like these 5 safes that don't really make any sense. And if the court were to grant the motion and grant that judgment in general, it wouldn't be it would be creating more problems, because there aren't 5 safes, Your Honor, at Mr. Ingersol's ex-wife's house. And there aren't any particular items even described in these safes by counter defendant in the motion. And the only other items besides these 5 safes, the Harley, which does need to be addressed, it are a few personal items that, you know, there's like a TV and a couple other items that defendant or Mr. Ingersol has no problem letting plaintiff sell. And he just, if the court would consider the divorce or the motion in its entirety, though, I think there would be more problems created, especially with regard to these safes, than if the court would just allow for additional time, 2 weeks. I mean, my client is incarcerated at the moment. The counter plaintiff has full custody. Custody is not being addressed in the motion. There is no reason really for the court to speed this up, especially with my client incarcerated at the time and unable to really communicate effectively with his attorney. And the point regarding the Harley obviously is well taken. That does need to be addressed. I'm just asking that the court give us time to address that amongst the parties. And I think that we wouldn't need but a week to make an arrangement regarding the Harley.
All right, anything further, Mr. Cadet, that you wanted to say?
Your Honor, the judgment gives 30 days to Mr. Ingersol to make an arrangement regarding the Harley. So delaying things a week or more is not going to help. We need to pull the plug on this marriage quickly and today if possible.
And again, oh, sorry, Judge.
No, I'm good. You know, my view, even if the court finds there's grounds for entry of a default as to Mr. Ingersoll's failure to answer the counterclaim, I think we have an issue that even under a default judgment of divorce, the court still has an obligation to make sure that the property division is equitable. And just looking at the proposed judgment, I have no idea whether that's equitable or not. So I think even I don't think the court's in a position to be able to adopt the proposed property settlement without a stipulation, because again, I think I need to be able to make findings that it's equitable, and based on what's been presented, I can't do that. And I mean, in particular, I have some concerns about these safes. I think certainly I need to hear more on that issue. So I understand the concerns, the time concerns, Mr. Cadet, that your client has. I'd be willing to try and set this for an evidentiary hearing as quickly as the court can get a date so that parties can present some evidence as to the assets and debts of the marriage and proposed property settlements. And then I can make some findings and enter a judgment. But in my view, I need to have the court needs to take some evidence as to what those assets and debts are and why the proposed judgment by the Ms. Ingersol is generally equitable. And of course, I mean, in that kind of hearing, Mr. Cadet, you know, as we all know, one of the factors in property division is fault of the parties. So, you know, Ms. Ingersol can make those kind of arguments, but the court would have to make findings and so forth. So the court will set this for an evidentiary hearing at its earliest possible date. And to the extent the parties are able to reach agreements outside of that, if there's a stipulated judgment of divorce, I have no problem signing that sooner. So that's where we're at. Mr. Cadet, anything further from your side today?
Yes, Your Honor. It did appear, based on the arguments from Mr. Hallman, that Mr. Ingersol might be able to or willing to make the Harley payments to try to mitigate the damages in this situation. So we're wondering if we're able to, by stipulation, enter an order today for Mr. Ingersol to make the Harley payments until we have complete resolution.
Mr. Hallman?
I don't want to agree to that without talking to my client officially, and I'm not trying to skirt the issue. I can promise to address that as soon. I thought my client would be logged in for this hearing, to be honest. And I plan on talking to him as soon as possible afterwards to get his explicit permission. And I can do that and let the court know. We do have a hearing at the, I'm so sorry. It's front of the court evidentiary. No, I have nothing else, Your Honor.
All right. Okay. Well, it sounds like we don't have any agreements for the record today, but again, the court will get this on the docket as quickly as I can, and so the court can make some decisions and get this resolved. That's all I have for today. All parties are free to disconnect at this time. It also concludes the court's morning